Well, guys, it is time. It is time to start this workshop that we have today. First off, welcome everybody. Good morning. For those of you that it's your first time here, very, very special welcome. For those of you that keep coming back, that were, at our monthly meeting last night, I commend you. Thank you so much for your persistence, your dedication to learning. We love it. So today, I'm Alexa, Operations Manager of BPM RIA Office. We have our CEO, Anish Jave here, as well as Michelle Suarez that is presenting today. She's coming from Florida Entrepreneur Law, and we haven't had her here yet, so we're excited. We had her, a little sneak preview before you came in one webinar, but we get to have some really good time with you today. We're going to be talking about securities considerations in real estate investments and why you should care. So just going to be really quick with our upcoming events. I need to add a couple events this month, so look out for those. I have at least two that I'm going to add on this month, so look out for those. And then in the following week, we have a little bit of a scary webinar coming up. It's going to be a little different. We always talk about the successes of our students, of all of our mentors, everybody that we work with, our speakers, all of their businesses, our vendor partners. This is going to be, getting a little dark. So we're gonna talk about it. We're just gonna talk about it. We're gonna get it out in the air. Because I think we can learn a lot from this. I think we can learn a lot from the disasters that have happened in these transactions. So look out for that. You can find all of our events on our website, bpmria.com. Put the link in the chat for you guys. And as you know, we do record our webinars and post them on our YouTube channel. So if you're not able to make it, we'll post the recording. Although it is the best to be here at the live event so you can get those questions in. It's not every day that you get to spend time with these amazing professionals and speakers that we have on here. So alrighty, just want to drop this for you guys. We just released the dates for the next boot camp. A lot of you were asking, when's the next one? I was saying maybe November, September 17th and 18th. So mark it in your calendar, everybody who missed it. We do have early bird tickets available, so go ahead and snag those right now as soon as you can, because it's going to come 4th of July and we're going to get busy, and so you want to get that price right now. So link in the chat for you guys, and if you have any questions, you can send me an email. It's 2 full days with us, money back guarantee. After July 4th of July, it will be $595 for non-members. So go ahead and snag that price right now. And our members, of course, they do get discounts, specials for pretty much everything we do. The boot camp, member pricing, special seminars, in person, online, special pricing, and the in-person networking meetings for free, and the National RIA Benefit Package. The same goes for business members that are in alignment with us. Florida Entrepreneur Law is one of our vendor partners. So you will see their information website on our website. So I'll put that link in the chat for you guys, where you can find these amazing people that we work with and recommend to you. So you can always check that out on the website, and link is in the chat. And last but not least, our one-on-one coaching and mentoring program is a solely one-on-one coaching and mentoring program for real estate investing. We put up 100% of the money for our students' deals and split profit 50-50. So if you want more information about this, you want to know what's going on here, highly recommend you go to the website right now and book the discovery call. This is where you will get a quick consultation with me, so we can book a meeting with you and one of our mentors so that you can discuss with them how this program may fit in your life. So info is in the chat, my email and the link to the website. Go ahead and do that. Going to be putting a bunch of helpful links in the chat for you guys today. So look out for those. And then of course, I will send you a thank you email after this event. But first off, can't go anywhere without thanking National RIA, our sponsors, Florida Entrepreneur Law, all of our corporate vendors, vendor partners, Anish, just Michelle, just everybody who's on here. We would not have these great events if it wasn't for you guys. So thank you so much for being here. And let's do this thing. Michelle, good morning. How are you? Thanks for being here.
Good morning. I am great. Even better now after your peppy morning music.
I know. I try. Put something on there. Wake everybody up.
And actually, just so you guys know, is that the webinar today in Florida Entrepreneur, it might sound familiar. It's because Amanda is her partner, and we've had Amanda speak. I think it was last month. I always forget, the dates go by so quick, but and she talked about corporations and setting up your corporation the right way. So this is her partner in crime, and I'll let Michelle introduce herself because we're very lucky to have someone at this level actually speak to our group. So
thank you guys. Definitely make me feel fortunate and humbled. So I appreciate the warm introduction, and we are very happy to be partnered with BPM RIA. We know the value you provide to your members, and we only align ourselves with organizations that we think fit our culture and vice versa. So thank you all for having us on again. So I'm just going to go ahead and get started with the slideshow. Don't worry, I've presented lots of times, and from what I'm told, I'm not terribly boring, which is hard to do with topics like this. But we are going to be discussing today securities considerations in real estate and why you should care. A disclaimer, this does not create an attorney-client relationship. Don't rely on any of the information that we're giving to you today, just to the extent that you have to consider that laws are constantly changing and the case law that comes out is constantly changing. So take this more as an informative session. And if you have any detailed questions about a specific situation you're facing, definitely reach out to us for a consultation. A little bit about me. My name is Michelle Suarez, born and raised in Miami, Florida. I'm a true Florida native. I was admitted to practice in 2013. I've been litigating for almost 9 years in commercial litigation. However, our practice has moved away from litigation, and we are now primarily a corporate transactional practice. I did work at 2 different big law firms. And if you don't know what big law is, big law are the big $600 per hour national large law firms. After a couple of years at big law, I realized that there was a community that wasn't being served. And so I founded Florida Entrepreneur Law in 2017. We've now grown. We have 2 partners and an associate, full-time paralegal, and a law clerk. We've got offices in Fort Lauderdale, Tampa, and Orlando, and we will probably be expanding some more soon. I'm also the incoming chair for the Corporation Securities and Financial Services Committee. That's a mouthful, but in short, that is a committee of the business law section of the Florida Bar. The Florida Bar is the organization that governs all attorneys in the state of Florida. The business law section is the arm or section of the Florida Bar that focuses just on business laws. We are the committee and the sections that are literally responsible for drafting the laws in Florida that affect businesses and corporations. So it's a pretty big deal. I'm very excited about it to be serving as the chair. And I'm not sure how that happened because I didn't move the mouse. And then there's some other credentials up there you guys can check out on your own. I have offered Alexa to share this presentation with you all after via email with the disclaimer that it not be recirculated and that all materials contained therein belong to Florida Entrepreneur Law, lawyer jargon. Okay, so now to the fun stuff. The main topics that we're going to cover today, securities is a very dense topic, and it is one of the scariest areas and most complex areas of law out there. Now, I've broken it down in a way that I think is very digestible. So we're going to cover these main sections. One is what is a security and the Howey test, which is something that you need to know to really understand what a security is. And I guarantee you, in most of the real estate transactions you're dealing with, or many of them, you are likely dealing with a security. The second thing is the duck test, what I call the duck test. and things that you should be looking for, and I'll explain more about that in a second. Sorry, I don't know why it keeps doing that. And then the next thing is the final wrap up. Securities is such a broad area that it's hard to cover everything in one webinar. But I am going to briefly cover very common other ways that you can run into securities violations. I want to leave enough time for Q&A. So while I'm going to run through these somewhat quickly, I will do my best to cover as much as I can. So what is a security? If you've ever heard of the SEC, the Securities and Enforcement Commission, they are the arm of the government that's responsible for enforcing securities laws on a federal level in the United States. They're mainly covered under the Securities Act of 1933 and the 1934 Securities and Exchange Act. These are the two main statutes federally that govern securities transactions. And then every state has their own securities laws, which in some cases may be preempted, meaning the federal laws trump it, but in many cases they don't. And so not only do you have to make sure that you're compliant on a federal level, you also have to make sure you're compliant on a state level. Most of us know securities as a note, a bond, a stock, but what many people don't realize is that an investment contract is also considered a security. So the Howey test is a test that we learned about in law school that every securities attorney knows, and it came out in 1936. It was about, of course, Florida, right? We had to set the precedent for securities laws, but we were, there was a group that was selling orange grove tracts in Central Florida, and they were selling it to investors with the promise that once the oranges were harvested, the investors would be able to share in the proceeds of the harvest. So this is where we got the Howey test from. And the Howey test, as you can read, states that an investment contract is a contract, transaction, or scheme where a person invests her money in a common enterprise and is led to expect profits solely, and here's the key, solely from the efforts of a promoter or third party. Okay, so in other words, if you are involved in a transaction on either side where money is expected to be returned without any effort being put in by certain individuals, you're likely dealing with a security. So what is the duck test? I don't know if any of you have ever heard this saying, but I have many times, and it says, if it looks like a duck, walks like a duck, and quacks like a duck, it's probably a duck. Well, the same thing applies to a security. If it looks like a security, it feels like a security, and it sounds like a security, it's probably a security. Now, there are 5 main most common indicators that most likely mean you're dealing with a security. I'm going to walk through them here, and then we're going to discuss each one in turn. The first one is that the transaction involves a pooling of funds. The second is that the transaction involves, like I just said, an expectation that profits will be received from the efforts of either one or a small group of other individuals. The third is that the deal comes packaged with other contracts, and I'll go into more detail about this in a second. The fourth is that the promoter or the seller is also, they still have a vested interest on the other side of the deal. So the transaction's complete, and that person who was involved in selling or promoting that transaction still has a vested interest in that ongoing transaction. And then finally, the sale only includes a fraction of an interest in the property itself. And I'll go more into detail about this in a second. So the first one is pretty obvious, and this is the most common one, which is why I listed it first. And that's that the transaction involves the pooling of funds. I have many clients that come to me and say, hey, Michelle, I've got a group of friends and we want to put all our money together to invest in startups or, real estate properties, or we want to start Airbnb or flipping houses and so on and so forth. And they think they just need, an operating agreement. That's not all. There's a lot more than goes into that, because by putting all your funds together, that means you are dealing with a security and must be compliant with securities laws, which I'll give you an answer at the end of the presentation on how we can do that. The next factor is passive income, and that's the whole efforts from others. And we all, I think most of us know what this means, but in short, it's that you don't expect to do anything, but you're still expecting to get a profit from that effort, from that transaction that you are getting involved in, or perhaps you're the one trying to attract people to it. That is considered a badge or an indicator of dealing with a security. And then the final two I've lumped together because they are a little not as common as the other factors, but they do happen as well. One of them is, there are a lot of real estate funds where you have what's called a sponsor or a promoter. And for the benefit of those of you who may not know, I'm going to explain what that is anyway, even though some of you may know. And that's a lot of times the sponsor will put maybe 5 to 10% of their own capital into the group, where the investors will contribute, let's say 5 or 10 million. And then the idea is that, they'll buy properties or commercial buildings and they'll rehab them and they'll rent them out. And then all that money goes back into the pool and the promoter gets a 10% or 20% carry interest. That is 100% dealing with a security. And a perfect case, which is an example of this, is the SEC versus TLC. The court said, as you can see, because the promoters' fortunes were inextricably linked to the fortunes of the investors, a common enterprise existed. And remember, that common enterprise language comes from the Howey test in 1936. And even though it's been all these years, it stays the same. And then finally is a fraction of the interest in the property. And what I mean by that is when you have a deed, right? And you have 6 tenants in common. And that means you all share an interest and a right to be on that property and the same ownership interest in that property at any given time. But if you were to take each one of your divisible interests by itself, and you really only own like 1/32 of the property, chances are you're dealing with a security, because in most cases, the only connection between all of you is that expectation to get a profit back. It's not the same as, and my stepmom actually is dealing with this right now. She's selling a property in Miami Lakes, and it's 4 children of a deceased person, and they own the property as tenants in common, and they're selling it. That's different. They don't own that property for the purpose of expecting a profit. They inherited that property as tenants in common, so that would not be considered a security. Now, you're probably wondering, okay, I scared you all, because you're probably going, oh shoot, I've definitely been dealing with securities. The nice thing is that what the security statute are designed to do is to protect people from fraudulent investments. They're designed to protect the public, but the government also doesn't want to stifle investment and development. So they came up with certain exemptions. And so under the Securities Act and the Securities Exchange Act as well, it says all securities in the US have to be registered. So when you hear of a company going public or being listed on the NASDAQ, that means they went through that registration process, which is super expensive, costs hundreds of thousands of dollars. And so Congress created exemptions from registration. And the most commonly used exemption is an exemption called Regulation D. There's also another one called Regulation A, but we don't have time to get into that today. Regulation D is the most commonly used form of an exemption for private dealings of securities. Sorry, I don't know what's going on with my slideshow. I have a ghost in my office. But coming back to this, so one of the ways that you can ensure that you are compliant with Regulation D is the biggest mistake that people make is soliciting. And what that means is if you are reaching out to Joe Schmo and somebody that you don't really have a substantial pre-existing relationship and saying, hey, I've got this great deal, you got to get involved, you're soliciting. And that may be permitted because Regulation D has 2 sections of it. Most people use 506B or 506C. And I'm not going to bore you with all of that, but all it means is, hey, if you are going to solicit, there's a list of requirements that you have to comply with. Or If you are not going to solicit, you can still sell your securities under Regulation D, but it has to be only to accredited investors. On top of that, there are documents that you have to provide as part of that investment. The most commonly known document and the most important is an offering memorandum, also known as a private placement memorandum. In addition, there are other documents such as subscription agreements, and there are all kinds of really creative ways to create investment vehicles through these types of schemes. But most importantly, in addition to the private memorandum, is the accredited investor questionnaire and the offer letter. Additionally, you have to know that within 15 days of you accepting any money whatsoever, or anyone signing a contract having to do with the investment of the security, you have to file what's called Form D with the SEC. And it's a very simple form, easy to file, but you do have to create an account with the SEC's portal called EDGAR. It's the electronic filing system that the SEC uses. Also, you should know, because you're in Florida, if you sell to more than 5 investors in the state of Florida, you are required to provide a 3-day right to rescission. That means they have 3 days to change their mind and cancel and get all of their money back.
Michelle, I just had a question about when you say a pre-existing relationship, can you define what that really means? Does that mean like, would you and I have a pre-existing relationship, or would that not count? Or I know it's kind of,
Yeah.
I sort of know Michelle, family.
That's a great question. It's definitely a question that comes up a lot. So it's a case-by-case basis. The court will look at all of the factors surrounding the relationship to determine whether or not a substantial pre-existing relationship exists, because that term, of course, is not defined. However, we have plenty of case law, and there are lots of no action letters out there which provide a lot of guidance, and they basically say this: if the nature of your relationship did not form or start just for the purposes of the investment, for example, you and I, Mitch, we've met professionally several times, we've established a professional relationship. At this point, we can say that we have a substantial pre-existing relationship, because if you talk to me tomorrow about some investment opportunity, you did not form the relationship with me for the purpose of that investment. We already had a relationship that pre-existed that, and so it would be treated as a substantial pre-existing relationship. I'll give you another great example. There are people always, and in fact, my clients ask me all the time, well, I saw this, company online that is saying that they're looking for investors and you just have to submit your information. How are they getting away with it? Well, what they're doing is they're trying to create that substantial pre-existing relationship. So if you create a website that, you're saying, oh, we've got like, in fact, oh my God, who's this guy that has one? I actually checked it out because I'm a nerd. Gary V. He's got like this Grant Cardone. He's got this whole real estate website. But when you go and you submit your information, what they're doing is they're taking your information so that they can talk to you first and find out, what is it you're looking for? Are you accredited? Do you qualify? Are you a sophisticated investor? To establish that relationship before they even give you any information about the investment. Now, that may not always meet the test of substantial pre-existing relationship, but if you can show that you took enough steps to gather information about the person before you told them anything about the investment, it would most likely meet the test.
Got it. And so Michelle, John's actually asking a question. So all the members in the BPM RE are substantial. So meaning, I guess, with that, I guess the question is, would that consider a pre-existing relationship? Like, for example, like I actually have a fund. So we have that, but let's say you started your fund, now would they, because you did this webinar, maybe that's what John's asking, not 100%.
Yeah, no. So I think I know where you're going with that. So let's say like it's different. Your members have already met with you a couple times. I would say if your member comes to like one meeting, meet you one time, and then you start, saying, hey, give me your money and invest in this, that's running a risk. That's in the gray area. Likewise, now I'm giving this presentation. If John contacts me and after our first call, I'm like, hey, you know what? I have a client that knows, and so it's not even my investment, right? It's a client's investment. And I'm like, hey, John, I've got a client that's got this great deal. And he sounds like he's offering exactly what you're looking for. Let me put you guys in touch. Not only is that a securities violation because we didn't have a substantial pre-existing relationship, but I'm also running afoul of something we're going to talk about later, which is I'm acting as a broker dealer without being a registered broker dealer.
Got it. Yeah, something as harmless as something, like, and I can see that happening all the time, right? It seems harmless, but it's important to know what you're violating. And I always tell everyone it becomes a problem when it becomes a problem, right? Like
100%, 100%. Because look, securities work, and I'll get to this at the end. It's not cheap because lawyers are terrified of it. It's a very scary area of law. Clients are terrified of it, and clients are just like, well, what I don't know won't hurt me. And sure, it's not a problem now. It's more, it's two situations most commonly where it can become a problem. Number one, when you're doing really well for yourself and you're killing it and you're making millions of dollars, that's when somebody somewhere is going to complain or find out about it and get reported. And then all of a sudden you've got an SEC investigation. Or number two, you've got an investor that passes away and then their heirs take over and their heirs start fishing through all the documents and the situation that they've inherited. And they're like, well, wait a second, this looks kind of fishy. They didn't comply with securities laws, and or I don't want any part of this investment. I want to sell. And you're like, no, you can't sell because you signed this. And now all of a sudden you've got a complaining investor, you've got a claim for investor fraud, and that is the problem. So that is why, is it expensive to comply? Not necessarily. And I'll go over that more toward the end, but it is much more expensive not to comply.
Yeah, and again, remember, Michelle's not giving you specific legal advice today, but obviously, thank God she's actually an attorney. So you'll laugh, Michelle, all the time. Everyone watches our webinars. I'm constantly talking about, I am not giving you any legal advice. I'm not an attorney. I'm not an accountant. All the above. But remember, we're giving you general advice, right? Of like the do's and don'ts. So today's webinar is very basic. It's just to kind of touch on different points in the industry as you start growing your real estate business, because I know a lot of you guys have talked to me, hey, I'm doing well with deals. And that's the common thing is that, hey, I got a bunch of friends, or we have family, we have money, and we want to buy properties. And, we've done webinars where we talk about syndication versus, or securities. And there's a big difference. So like the securities end of what, Michelle's going over is really the next step. Above, syndication is probably what I would say.
Yeah, it's different when you have, if it's a group of you and you all know each other well and you're putting your money together, you are definitely still dealing in securities, but it is a lot easier to comply at that level. Once you start talking about, hey, my aunt, her wife, who I don't know, and all these examples I'm giving you guys, just so you know, are real client examples, wants to invest, but she's not an accredited investor. Okay, that's fine. But that means now we have to have these disclosures. We have to have a questionnaire filled out, and you got to keep all that in your record book, so that if Aunt's wife ever complains that she was defrauded, you can point back to this paperwork and say, no, we did what we were supposed to.
Yeah, and you'll probably get in. I don't know if it's probably in your slide, so I might have jumped the gun a little bit. Can you actually define what an accredited investor that might be?
100%. It's not in my slide, but lucky enough, I have it memorized at this point. So the main definition. So an accredited investor has several different types of people or entities that qualify as satisfying the accredited investor status. But the most common that you will run into, definition used, is the person has, and I say person as in a natural person, not as in an entity, which I'll get to in a second. The individual natural person has a net worth of $1 million or more, not including their primary residence. So you can't count their homestead house. My wife and I, we have a house downtown Fort Lauderdale. It's actually 2 adjoining lots, and it's definitely worth 1.5 or more because of the size of the lots. But that would not make us an accredited investor because we can't use that as part of our definition because it's our primary residence. You have to consider the value outside of that. Or the individual has made $200,000 for the last 2 years in income and plan and can reasonably anticipate that they're going to make another 200,000 in the next year. Or if they're married jointly with their spouse, make 300,000. Same thing for the last 2 years, and they expect to make in the next year. If you're dealing with a trust or an entity, they have to have a net worth of $5 million. And it can't just be an entity that they set up for the purpose unless it truly has a $5 million net worth in that company or that trust. And then there are other exceptions like banking institutions and all of that. But the most common accredited investor that you're going to be looking for is that 200,000 annual value income, or if married, 300,000 or $1 million net worth. Additionally, regulation D and A and the accredited investor definition was also revised recently, and they added lawyers, CPAs, and certain financial planning advisors also qualify now as accredited investors.
Okay, yeah, thanks for clarifying that. The other, and I know I'm just going to piggyback on that question. I know you were talking about there's a questionnaire. So how does, like, I know you give quote unquote the person that wants to invest the questionnaire. How do they, if you're setting up the fund, or like, how do you verify that? Do you get, a bank statement showing they have $1 million, or a personal financial statement, a CPA letter, or like, just to make sure you're in compliance?
So there's a couple different ways. There's 3 main ways. And the rule actually gives you a list of different ways that you can verify that are non-exhaustive. But the 3 most commonly used ways are one of the following. 1, you give them a full questionnaire which walks through their net worth and value, and they do have to provide financials to substantiate that. And then you or the client has the onus of reviewing that. And let's say they doctored their financials. It doesn't matter, as long as you had a reasonable belief to rely on what they gave you to verify and think that they're an accredited investor, you're okay. The SEC won't mess with you. However, how many investors want to give their financials? A lot of them don't. Not only is it burdensome, but they just don't want to share that information. So another common way, and it's one of the most common ways used, is there is a form that can be filled out by either their CPA or their attorney that vouches on their behalf and essentially states, I've reviewed this person's financials. I can verify that they meet the definition of an accredited investor. And then the final way, which is becoming more common, there are third-party platforms out there that will, like websites and companies that will collect a person's information, and essentially, like the attorney or CPA letter, will give them a letter stating that they have verified this person's financials and they can verify that they are a true accredited investors. And in fact, I even have clients that through the PPM documents, the private placement memorandum documents, will redirect the investors to that website, and they'll have like a code so they don't even have to pay for it. They fill out the information, that third-party website will verify that that person's an accredited investor. That information will get sent back to the issuer, the company offering the securities, and then we're good to go.
Yeah, thanks for clarifying that. I know, like, people like, some people don't know what an accredited is. Am I really accredited or not? Or, I make X amount, especially here in South Florida, right? I make X amount of money, but is it verifiable? Or Is the property really worth this? So that's one of the differences. Yeah.
Yeah, definitely. And, a lot of times, just to segue back into this, where we're at in the presentation right now, a lot of people will say to me, well, why should I care? Why do I care if the securities laws aren't complied with? Well, as an investor, you should care that the deal that you're working with is following the proper steps, because you're at risk of losing all of your money. And the statute of limitations is only 2 years after the fraud should have been discovered, and not more than 5 years after the fraud has occurred. And listen, this happens all the time. I'm withdrawing from a case right now because I feel terrible for the guys, but I mean, they can't, anyway, I won't divulge the information, but they got defrauded, and it was an investment scheme in a CBD enterprise. So that's the risk if you don't care about checking to make sure that the deal you're being brought into is compliant. And then on the other side of it, if you're the one putting the deal together and trying to attract investors, you can be personally sued for fraud, which can expose you to not only fines, but actual prison time. So, and I don't, I don't do white collar defense. I can refer you to an attorney. So it's much easier and cheaper to comply.
Yeah, and also like obviously if you're setting up your own fund and raising money, the other reason with accredited investors, I mean, let's just I'm just going to kind of say it is unfortunately there's a lot of unscrupulous people that make money in different ways. So you want to make sure it's verifiable, and I don't know. I guess the easiest way I'll say it's clean money. I don't know any other
Yeah,
nice way of saying
definitely.
that. Because you want to make sure they're investing, and I know you're excited, that people are investing in your project, but you want to make sure these steps up front, because it like what Michelle's talking about, you put your whole investment, on I don't know, like on notice, if that could say that you may lose everything, and you're even talking about jail time and all the other things that you might violate federal law. So with the SEC.
Yeah, and a lot of times, like, people don't realize it only takes one person in the group of investors to complain or report you for the whole house of cards to come tumbling down. So I feel like, let me make sure I didn't skip a slide here. Okay. So steps that you can take. I mean, you guys are going to think that this is my pitch, and of course it's part of a pitch, but it's also the truth. What can you do? Hire a lawyer, experienced in dealing with securities. Now, one of the things, and I don't care if it's not us and it's someone else, but one of the things that people don't understand is that when you are consulting with an attorney, you're interviewing them too. You have every right to ask that attorney, hey, have you ever worked on this kind of deal before? Or when was the last real estate deal you worked on? What's the maximum net worth of the deal that you've worked on? Have you dealt with Regulation A before? Like, you can ask them the questions, and they should be very comfortable in being truthful with you. Listen, before I ever worked on a real estate investment deal, there was a point where I didn't. And I would always disclose to the clients, look, I've never done this before, but I feel we're well-versed enough that I can. Now I can say I've done plenty, but you see what I'm saying? You need to be comfortable with asking your attorney those questions. And if they get uncomfortable, that's probably not the attorney for you. Also, be upfront with your attorney about what you're trying to accomplish. A good attorney should not expect you to know our legal jargon. We need to be able to talk in common sense, person to person conversation where you can just tell us what it is that you're trying to accomplish so that we can help you accomplish that. And then the second step is follow step one, hire an attorney, but do it before you sign the paperwork, not after. Why? Because we can't cure a securities violation. We're not magical fairies. Like, I have a very large school that is not in the United States, offshore, but has one of their parent or subsidiary companies here in Florida. And they came to me for a securities opinion. And I had to tell them, unfortunately, that they had committed securities violations, and they were very frustrated and they wanted me to fix it. And the problem is you can't fix it. You can't undo it once you've done it. Now, you can take steps moving forward to make sure that you do things right, to avoid an SEC investigation in the future, but there's nothing you can do about what you've already done. That's why it's so important that you come to us as early as possible when you're considering these deals, so that you can budget it in and we can figure out what are the most important steps that you need to take. The other thing is, if you approach not just us, any attorney, listen, I've been practicing for almost a decade pretty soon. And I know a lot of attorneys in different practice areas, but I know a ton of attorneys in the business law area. And I can tell you, we're all super busy. And so if you come to us at the last minute, one of two things might happen. Either one, we won't be able to help you, and you're going to end up with a door law attorney. And if you don't know what that is, that's an attorney that takes whatever walks through the door. You don't want to end up there. Or two, we're going to be able to help you, but you're going to pay a premium on that. So our hourly rate is going to shoot up because you need something fast, which means it's not fair to our other clients, and we got to bump their work down to move your work up. So keep that in mind. The earlier you come to an attorney, the better. And then the last thing is set a budget, be realistic. And I will go over what to expect budget-wise at the end of the presentation to help answer some of those questions. It's not cheap. I always say, I don't know if I can afford myself, but I will tell you this. I have, and I really shouldn't say that, I've hired my own attorney friends for other things that need to be done in areas I don't specialize in because I know how expensive it is to end up in a lawsuit. Why? Because I've been litigating for almost 10 years.
Yeah, and Michelle, I'm just going to add to that. Like, when you say it's not cheap, it's what I'm going to say. It's all relative.
That's true.
Right? So meaning if you're raising, I'm just going to use as your projects are getting bigger, 10 or $20 million, X amount is less than whatever percentage. So I think that's always a different end of when you think about cost is number one. And the number two thing, I'm just going to be sarcastic about it, which I laugh because I know Amanda too. I know you have over 10 years of experience. I don't know what you guys drink. You guys look so young. You and Amanda combined, I always crack up. I'm just laughing my ass off when I
Well,
say.
thank you. I appreciate that, especially seeing as I turn 39 in like 2 weeks. So that's very much appreciated.
Yeah, it's just pretty funny. I just kind of crack up because when Amanda was on too, I was like, don't let her fool you. Like she's tough. She knows her stuff. And I'm going to say the same thing about Michelle too. So, as I said, I don't know what you guys are drinking in the water.
Vitamins and yoga.
Send me some.
Okay, so the last thing that I wanted to cover before I get into expectation is that another way that a lot of people run into problems is that they'll come to me and say, hey, so I want to pay my guy, this friend, a broker fee or a finder's fee for introducing me to this investor. And I'm like, whoa, don't tell me that, okay? Because everything's protected by attorney-client privilege, but I also can't help you commit a crime or I can lose my license. So don't tell me, I don't want to know. And number two, that person is acting as a broker dealer. And a broker dealer, defined by the Securities Act, says that it's anyone who's in the business of affecting transactions and securities for the account of others. And of course, they don't define this, but they've come out with a bunch of letters that provide guidance. So if you're structuring deals for other people, if you're trying to solicit investors for other people or for yourself without complying with the exemptions we talked about earlier, if you're screening investors, if you're negotiating a transaction for someone else. As a matter of fact, even if you look at number 8, I have issuing confirmations and creating records of transactions, and in the notes I have Think Digital Assets Exchange. This is because of a real client I have that I'm dealing with. And as soon as I saw it and I heard the technological inner workings related to real estate of this thing, I was like, oh, securities flags are going off, securities flags are going off. But I haven't dealt with this particular issue yet, and digital assets are still very new to the SEC. So I started doing my research, and sure enough, I was like, well, wait a second, we can do this, but we have to register as a broker dealer. So just be careful whenever you're soliciting people or having people solicit for you, because it can be a violation of the broker dealer registration laws as well. Now, there are a lot of exemptions from having to register as a broker dealer. One of them is buying and selling securities for yourself, not as part of a business. So if you're just trading securities that are yours, not as part of a business scheme with other people, you're good. If you're conducting all of your business in one state, you should be good, but you may have to register in that state. And then finally, if it's your startup and you're issuing your own securities, as long as that other Regulation D stuff we talked about is complied with, you should be okay. And then as far as this is the contact information, so I'll leave it up for a second before I take the share screen down. But in short, people will ask me, well, how much does this cost? Well, that depends. If it's a small, simple deal, we're not talking about dealing with non-accredited investors, because then there's another list of compliance that you have to go through. If you're dealing only with accredited investors, you're not dealing with more than 35 people who are non-accredited investors. A Regulation D compliance investor packet on average will cost you anywhere from $10,000 to $15,000 in legal fees and CPA fees. Now, don't freak out. That's not all paid at once. Our retainers are not $15,000. Maybe one day they will be, but we don't want to, we never wanted to be that firm. We want to make things palatable, and you paid over time because number one, we can't prepare all your investor documents in 1 month. We ain't got time for that. It's stuff that happens over time. You have to put your business plan together. We have to prepare your private placement memorandum. So it's, when I say $10,000 to $15,000, that's over the course of a few months while we prepare everything. So we have to make sure your corporate documents are in place and all of those things. And then as far as there's other exemptions like Regulation A, which are more expensive, but you can offer to the public. You can raise money through the public. So there are lots of budgeting friendly ways. It is a lot more expensive at the national level law firms, but rightfully so, because this is an area that's ripe for litigation. And as far as just having hiring a lawyer like us to just review your contracts is not going to cost you $10,000 to $15,000. It'll cost you anywhere from, let's say, a simple contract. Our simple contract retainers are $1,500, and our general corporate rep retainers, as of now, today's date, is $3,000. So you're looking at anywhere from, I'd say on average, $1,500 to review a simple contract to like maybe 3 or 4 if we're negotiating something for you, like a share acquisition. But I'm going to stop my screen share now and see if you guys have any other questions for me.
Yeah. So Michelle, I'll get a couple of questions that I'm getting privately. So a couple of things is, it sounds kind of basic, but what state are, do you open, like, let's say I want to, start a fund, or do you open it in Florida? Is it in, I'm always so confused, like, should it be Wyoming or Delaware, or is it?
I love this question. Yeah. I love this question. And I'm going to tell you a true story that led to something that is going to segue into me answering this question. I worked on a real estate deal, a fund. It was an equity group, and then a guy and his brother, and that was it. It was just them 3, but they were pooling between 10 and 20 million. And they were going to put it together to invest in properties in, I believe we had Ohio, North Carolina, Tennessee, and eventually Florida. I was originally hired to represent the fund, and then the equity partner that was part of the fund has their attorney from, I almost said the law firm, a very large, well-known national law firm. And when we were working on a deal, I proposed the entities be formed in Florida because the equity fund was here. The guy and his brother were all here in Florida. They were going to be running their operations out of Florida, even though the properties were all over the United States. And the guy on the other end of the deal, this old timer, was like, well, no, we need to incorporate in Delaware. And I was like, okay, do you know why? And he's like, well, because we set up all of our funds in Delaware. And I'm like, oh, okay, you're licensed in Delaware? He's like, well, no, I'm not, but I'm sure our firm has someone licensed in Delaware. I was like, okay, can you please explain to me the reason why you would incorporate in Delaware? Because I know the reasons why people incorporate in Delaware, but for a real estate fund, it really serves no purpose unless there's a specific investor that's requesting Delaware, or you've got property in Delaware. And he's like, well, no, because that's the way it's always been done. Delaware is the state everybody incorporates. Anyway, that didn't go anywhere. And we ended up incorporating in Delaware because, big law firm wins the argument. And so I went on a quest, and my article comes out next month with a partner at this same law firm and a UF professor that talks about the comparison of Delaware versus Florida versus other states, mainly Florida versus Delaware. And here is the thing. Delaware is advantageous 100% for the reason that Delaware has the oldest body of corporate law in the United States. So what does that mean? That means we can easily predict the outcome of decisions when there's business disputes internally among the owners of the company. We can pretty much predict what's going to happen because Delaware already has a case on it. However, if you register in Delaware, you have to pay franchise tax based on the value of your shares or the value of your business. You have to pay it every year. You have to pay the registered agent fee, and the franchise taxes are very expensive. They can run up to $400 or $1,000 a year or more. People don't realize that.
Wow.
Everybody's like, oh, well, it's very private. You can just request, all you do is pay a fee and send it to Delaware, and they have to send you the articles of incorporation. Wyoming and Nevada are actually the most friendly in terms of keeping who the investors are private, and so it's not publicly disclosed. But there are other ways that you can structure that as well in Florida. My advice is, if all of you live in Florida, and not necessarily if the properties are even here, but if the people who are investing in the group are in Florida, just incorporate in Florida.
Yeah, that makes, I mean, it makes a ton of sense. It's just funny when people ask that. Let's see, someone's asking, let's see, how many co-sponsors can be in a fund in Florida? And what's the co-liability between co-sponsors?
So that's all going to be subject to contract interpretation. A lot of sponsors are set up as limited liability partnerships or general limited liability partnerships. Sometimes they are set up as LLCs also, but that is going to determine who the sponsor of the fund is. So the sponsor of the fund may be one entity or it may be two entities. That's all contractually organized. So it's up to you. Typically, you'll see one sponsor in most funds that I've come across, but that's not to say that you can't have more than one.
Got it. Yeah, and the other question I always get too is someone just sent me is, and you kind of touched on about the non-accredited. Like I do have people that are non-accredited, and they don't want to display. And actually, you know, some of you guys might know I'm Indian, so in our culture, it's kind of funny because I have a good friend, family friend, attorney out of New York, and they could be, you know, they are, you know, definitely 100% accredited. But they just don't want to show their financials. They're just adamant on that end of it. So is there a way to, and I know you mentioned up to 35 non-accredited investors.
Yes.
So how does that work?
So you can have up to 35 non-accredited investors and still comply with Regulation D if everyone else is an accredited investor. However, for those 35 non-accredited investors, you have to take extra steps to make sure that they are, excuse me, I'm recovering from COVID, that they have, that they are considered a sophisticated, business savvy individual that is capable of evaluating the merits and risk of the investment. So that is very vague.
Yeah,
I know. But basically what you have to do is you just have to show that you've taken steps to disclose all the information to them about, do you put disclaimers all over that PPM? You have taken steps to verify that they can bear the financial risk of losing all of their money in this investment. And you want to make sure they don't exceed 35. And then the other thing that I forgot to mention earlier is if you're dealing with investors in other states, or I did mention briefly, you have to also make sure that you're compliant with that state's security laws.
Oh, good point. Yeah, I didn't even think of that. And actually, then I'm going to follow. This is my own follow-up question based on that. You know, especially living here in South Florida. What about foreign investors? Meaning, you know, how does that work?
Even though this is beyond the scope of today's CLE, I've been doing this for a little bit now. So Regulation S is another regulation where it covers when you're dealing with investors that are in foreign countries. However, if they are investing here in the US, you still have to make sure that the transaction itself is compliant with Regulation D, even though that person, individual, or entity from outside of the country doesn't count against those 35 non-accredited investors. They don't count at all.
Got it.
As far as like satisfying that number. But Regulation S is a whole nother nightmare of regulation, which I know enough about it to be dangerous, but I've never had to do it yet, and it's very burdensome.
Okay, yeah, and the reason I bring that up, living here in South Florida, I see a lot of groups, you know, even through through BPM RIA that, hey, I have some funds that I raise money, you know, in South America, we're buying properties, and you know, I mean, I feel like they're in violation. You know, I'm not the, you know, SEC police, but I'm just like, wait, so you're just pulling some funds, and you know, like and not even, you know, my background's been banking, so like the other end of the banking is the money, you know, where's the money coming from, and are you following all those things?
Yeah, because then you have the Foreign Corrupt Practices Act and a couple other federal statutes now that cover all of that, and now we've got the Corporate Transparency Act, which we're still waiting to get regulations for, but pretty soon in the US, and I'm upset about this, and I know a lot of business attorneys are upset about this. Every single person that owns any kind of interest in any company at all in the US have to report who their beneficial owners are of the company.
Wow, I didn't know that. And I know that's part
So
of,
that's gonna be a whole nother CLE.
yeah, I know that's been happening because of, all the, I don't know, whatever you want to say, legal money coming in. And I know
That's
they're
exactly why.
especially with the, they're washing it or whatever you want to say through real estate. And I know living in South Florida, we're a hot spot for that. New York is, where they're just moving illicit money throughout, our economy. And I get a chance. And by the way, today's not supposed to be political by any chance. So my bad on that end of it. But, as these laws happen, right. And I think that's why it's important to have I constantly talk about, building your team as you're building your empire. And you actually need a good attorney that's, again, that you actually touched on, that specializes in this. All attorneys are not created equal. And it's the same thing as like, doctors, right? You have a heart problem, you're not going to the podiatrist.
Right. I use that example all the time too, because even us, like even within our own firm, if somebody comes to me with a Regulation S issue, I'm going to briefly look at it and then I'm going to refer them out to somebody else who specializes, because it's very easy to screw up a client's, situation or documents or get them into trouble if you don't know what you're doing. And unfortunately, and I'm reluctant to say this because I know a lot of practitioners that are super ethical and they stay on top of, the case law and the statutes. And there are also, unfortunately, some practitioners out there that hold themselves out as being well-versed in an area that they're not well-versed in. And they can potentially not only screw up a deal with SEC situations, but they can cause you tax consequences.
Right. That makes a big difference, obviously. What about like, and I know you were talking about, setting up the PPM and the fund. What's the time reference in general? Like, let's say I'm a type A person. So I'll have my business plan. I'm really excited. So I move, everything you tell me, I'll have ready.
Mhm.
Generally speaking, what is like the time from inception, from when they hire you till you're approved? Is it 90 days, 60? I know it probably depends on how fast I got you the information, obviously.
I was just going to say, a lot of that is dependent upon, number one, yes, how fast the client gets us the information, but also where in the process the client is. If the client is coming to us with an idea, that's going to look very different than a client that's come to us that maybe, and their knowledge base, right? Maybe they already know and are somewhat familiar with these types of real estate structures, and they've already got all their entities set up, they've got all their moving parts, and they're just coming to us for preparing the PPM, and they've already got their operating agreements and all of that in place. I actually have a client who's like that. And so for him, he hired us in November, and we got the investor documents out. I want to say it was March. By the end of March, we had the investor packets out. So I would say 3 months is a decent average.
Okay. And then the other
he was
question.
super organized.
Right.
So that's why 3 months.
Yeah. So, and that's why I thought it's important, because I don't want people to think, oh, I'm going to call up Michelle in 2 weeks, be up and ready, because I want to, I'm going to throw an event or I'm going to do something, and on that end of it. And then like even like I had this question, this is a common question for me, was like, how do I know, like, what number, is there like a minimum amount of number I should be, to set up a fund? Meaning, like, if I'm only going to raise $1 million for a project, I know it's not much here in South Florida, but should I set up a fund if it's only $1 million, 5 million, or 10 million? What are your average clients? And it doesn't have to be just a real estate fund, guys. It could be startups on different kinds of.
We've dealt with as low as, like, our last investor packet that we set out was for $65,000.
Oh, wow. Okay.
Yeah. And I mean, he needs to raise a lot more than that, but that's what he's got right now on the table. And then, versus the other guy that we closed in March, he's looking to raise 10 million. So it depends. It varies across the board. I think what matters isn't how much can we raise, it's which exemption are we relying on? Because if we're relying on Regulation D, the nice thing about Regulation D is you can raise an unlimited amount of money. That's why a lot of people use it too. Now, if you're relying on Regulation A, which is another really nice exemption that's available to people that want to raise money, because you can actually solicit through a website or portal, but there are reporting requirements and it's more expensive. We average out a cost of at least $30,000 for that. But what was my point in this? Oh, with Regulation A, there's tier 1 and tier 2. Tier 1, it's less than, I want to say it's 25 to 50. I don't remember, but tier 2, which is the one most people use and the ones that my clients have tried to get an exemption under, is you can raise up to $75 million. So it depends on which exemption you're relying on. In most cases, Reg D, Regulation D, is the easiest one to comply with, and you can carte blanche raise as little or as much money as you want.
Yep. And by the way, I'm just going to let our audience, so I mean, first of all, I know Michelle and I are geeking out like on, on stuff. So this is why you need an attorney that's going to lead you the right way. So it's because I've asked all these questions in general. So don't get overwhelmed when you hear A or, C or D or any of those things. Again, this is why you're going to have an attorney that understands this, because they want to know what your goals are.
Yes.
Like what happens if, what happens if I did a Reg A, right? And then I want to change it to Reg D.
Right.
Can you actually change it? Or obviously
yes,
there's a cost,
you
but
can.
how does
So
that
you
work?
can rely on, you can go from one to the other, but there is a slew of formalities that you have to comply with. In addition, there's a period of time that you have to engage in the raise. For example, Form D has to be renewed every year. Now, there were amendments recently made to both Reg D and Reg A last year, and you have to be really, well, there's a 30-day window now where you can close one raise and wait 30 days and then start a separate raise. So let's say I'm doing one raise under 506B. 506B is no solicitation. I'm only dealing with accredited investors or 35 or less non-accredited investors. Okay, but I can't solicit. I can't try to get my neighbor to invest or advertise on Instagram. But let's say I now want to switch and I do want to solicit. I want to, and this is a real example again. I've got a group of, wealthy individuals in my community, and we want to throw, they're putting this event together and we want to pitch our business to these specific wealthy individuals. So now we're doing solicitation. So we're going to be under 506C. Well, the rules require that whether it's from Reg D to Reg A or between 506B to 506C, which are two different exemptions within Regulation D, I have to wait for a certain amount of time to pass before I can now engage in this other type of raise under this other exemption. Additionally, if they overlap for any reason, whichever one is the more restrictive, you're going to have to comply with. Regulation A is super restrictive, but it is worth it, even though it's expensive. Well, not expensive, like you said, it's all relative. If you're raising $10 million, $20 million, who cares about $30,000? It's a drop in the bucket. But when you're doing it, you do have to wait a certain amount of time, which and don't hold me to this. That's why I said don't construe this as legal advice, because the amendments just took effect in November of last year, and I'm actually putting a panel together for me to learn about it as well. I believe it's 30 days now that you have to wait. Now, that doesn't mean, that's not the same as reselling your own securities. Right. That you have to be very careful, because once you have your securities, there's another, I don't want to overwhelm them, but there's another rule called 144 that has to do with resale of securities. And not only that, when two transactions are considered integrated. So you have to be careful, because let's say it's June and I'm only offering my business's interest to accredited investors. And then I want to start soliciting, and I want to do it in August, right? So I can give myself that 30-day window. But I decide that I don't want to wait, and I solicit before on July 31st. It's right at the cusp. And I didn't verify that everyone I was soliciting was accredited. So that transaction in August, I just blew my exemption. And because they're so close together, there's a high likelihood that transaction in August will blow my exemption for June. So now the whole thing has to be compliant with 506C, which is the higher threshold. I know this is all very confusing. My point is, you got to be careful. Don't tell people to invest in your company without a securities attorney involved. Don't make any false promises. Don't put anything in writing you're not going to honor.
Absolutely. And that's why I was laughing. I know that's why I'm letting our audience know it's just because I've been through this. And if you guys didn't know, that's why I wanted Michelle to speak to our group. She knows, like these are the kind of questions you want to ask, or you're going to like in the beginning, you don't even know what you need to ask. But as you start, getting involved and start building, and you might set up multiple funds for different projects, for different
Yeah.
things that you're doing. So you want to
100%.
learn like the basics. So between the three different kind of funds, at least now you know what the price points, generally speaking, will be in the realm, right? It's not just going to be, hey, I'm going to spend $1,000 on opening up a securities fund, or because some of the things I always hear people that tell me like, oh yeah, that's nothing. It's only going to be, 1,000. I'm like, what? Like, what world are you talking about? Like, are you sure? Like in the
Yeah.
US, like, so I'm always like worried. And at BPM RIA, like, I really stand for people doing things the right way. And obviously,
Yeah.
I am nowhere close to being a securities expert, by any chance. So that's why I always like having Michelle on and, asking these tough questions. And she's in it, with working with real estate investors and other investors.
Yeah, this is definitely, this is a little further on into real estate investing and as far as sophistication goes, but it does not have, there are levels, it does not have to be, it's probably scarier than it sounds, but it should be at the same time. It's like, you want to make sure you comply, but you don't have to think you have to spend $30,000. You just have to think, okay, what level am I at? And where do I need to start tightening things up to make sure I'm doing them correctly? And then the other thing is, once you set up a fund, like you were just saying, Anish, when you do it right for this fund, now we're just duplicating those efforts for
Yep.
your other funds. So it's not like you're spending another 10 to 15 grand every time.
Right. And now you have a track record too. So that's why it's always important. And what we're talking about also doing it the right way is, like for you guys that I know a lot of you guys are flippers or, fixing houses. It's the difference between doing a house with permits versus without permits. Can you raise money and, for projects? Yeah, you could pretty much do anything you want. And the problem happens again when it becomes a problem. And what
Right.
you've noticed, right, is all, and Michelle said this numerous times, which I got, all it takes is one person to be unhappy about anything, right? Like it could be time. And I didn't even think about the heirs when someone passes away. Like that didn't dawn on me. I was like, wow, that's true. Like, does my wife want to be in this? You invested X amount of money into this thing. Like, no, I want that money. I don't know what he put it in.
Yeah, and on that note, and I know that this is digressing a little bit from the topic of today's presentation, but I think it'll benefit everyone, and I'm sure Amanda touched on it in her presentation. One of the main, look, securities is a very niche, small part of what we do, because only a certain level of individuals, number one, can afford what that costs, and number two, are at that sophistication level to know that they need that. But the bigger part of what we do and what all of your members need to always consider is, even when it's just you and one other partner, and again, all of these examples, I literally have clients' names in my head as I'm telling these stories. I've got a client right now, she's been investing for years, she's a real estate broker, and she's been now she's in North Carolina, but their entity is here in South Florida, and she's been investing with this guy that was the money man from Colombia, who now lives in Mexico, for years, and now they had a falling out. And the operating agreement they had in place from decades ago has never been honored. They haven't followed anything that's in it. So what was the point? Like, you have to have these corporate documents in place that are realistic, that you understand, and that accomplish every single scenario. What happens if somebody dies? What happens if somebody gets divorced or files for bankruptcy? What happens if, somebody buys another property and we have a deal that, we're not going to go and compete with each other? There's a lot of, or that we are going to be allowed to compete with each other, because you can do that, but you got to carve it out. So those are all like really important things to think about, even before you get to the securities part of it.
Yeah, and you're right, Amanda. I mean, we talked about that for a while. She really crushed it, and when she was talking about that portion. So, if you guys are looking to even set up a fund, remember that their firm could do all of it. They could set up your corporation, help you with the operating agreement, and so it's not just like, hey, I already have a company. They could help you from inception, to completion, or if you've already set up your company, your LLC, and you had an operating agreement, and now you want to take it to the next level and really raise money, so it depends on what portion you're in. They could handle all that. So I think that's always important also. And you guys also, I mean, I know we're talking about securities. We might as well talk about the firm. Are you guys also do contract law too?
100%. That we live in contracts every day, all the time.
Yeah. So
that is the world we live in.
Yeah. And especially like you guys that are doing commercial properties, like it's going to be a lot more complicated than just trying to use a FAR commercial contract, generally speaking. So I mean, we might as well just talk about like some of the services you guys offer, because I'm not sure. I know those are the three that I know that you guys offer.
Yeah. So we call ourselves, the law firm for doers and dreamers, and we really mean that. We represent everything from, real estate funds to CBD companies to all kinds of companies. And the reason I say that is because the best way to understand what we do is we are kind of like your holistic preventative law firm. We listen to what it is that you're trying to accomplish with your business. And then we look at, okay, this business is in this industry. These are the contracts they're going to need. This is the brand protection they're going to need. Let's say you're not just doing a real estate fund. Maybe you're putting together like BPM RIA, you guys have a brand, you have a trademark, you have a word mark and materials, all of that material, that's all intellectual property that's protectable. So we do intellectual property protection. We do contract review and drafting, and people, they'll think of contracts as just operating agreements, but it's so much more than that. I just did a mineral rights contract for a company between Florida and Singapore. So there's all kinds of contracts that we do that we specialize in. And I promise you, if there is ever a type of contract or area of law that is new to us or we're not comfortable with, we will pump the brakes and tell you, listen, this isn't something we specialize in, but we know this person who does, because we align ourselves with people who are like us that only serve a certain niche area of the law, which for us is startups, entrepreneurs, businesses.
Yeah, absolutely. And because I do get these questions, and I know I think I probably already asked you. So like, I know Michelle's network is massive. So I know some people will call us and ask us for bankruptcy attorneys and of that nature. So they like, she's well diverse in the legal field. So, and that's what I really appreciate actually about Michelle and Amanda. I've called Amanda on different things and she's like, hey, Nish, we don't really do that, but I have somebody. And I love that honesty, right? Like versus saying, oh, I could kind of figure this out on that end, and which I really appreciate. Both of you guys do that consistently.
Yeah, we're definitely not we'll figure this out. We already deal in areas of law that are so specific and nuanced. Like franchising is another big one. I don't know if she's discussed that with you, but franchising is something that we've become very well versed in, and we do a lot of on the franchisor and franchisee side. And it's a very niche area of law. So yeah, we won't do it unless we're confident that we can do it.
Yeah, but John's asking, do you do any creative financing stuff, meaning subject to contracts, land contracts, or innovation?
No, like mezzanine financing and all that kind of stuff. No, we don't do any of that kind of stuff.
Okay, got it. So, and you probably have someone on your network that like.
So we've got a couple real estate attorneys. I know for sure one of them does. And actually, that's not true. I just worked on a deal for a restaurant closing a couple of weeks ago, and it was funny. I found out at the closing he specializes in these really nuanced real estate types of financing structured deals. So yes, I do have someone.
Okay, got it. So sounds good. Yeah, I mean, those are the, as I said, like you guys do a ton of different things that a lot of people don't do, and it's very niche in what you do, which I appreciate, on that end of it. So I know we're almost out of a little bit of time. I'm trying to I answered a lot of these questions that actually came privately to me. Is there any last couple things that you would suggest for investors, or like in general, and they want to explode their business, is probably what I would say.
Yeah, definitely. I would say is I think if you approach the whole, how do I get my business to be legally healthy, is to really take it in phases. Phase one is making sure your corporate structure is appropriate and properly set up. Step 2 is identifying what your objectives are in the next 1 to 5 years and making sure that your business attorney knows of that so that they can start putting the things in place to protect your business as you grow.
Right. And you know what? I just got to think. What happens if they've already set up a I think Amanda answered, but I'm just going to ask you the same question. Is that they set up their corporation and then they realize they don't have an operating agreement. They don't have. Do you guys provide services that like I went to sunbiz.org. I set up my corporation, so I don't have any minutes. I don't have an operating agreement.
We get a lot of those, especially when they're actually at this level. So I'll get a lot of securities clients that are like, okay, I've been sitting with this company for 4 years. I'm ready to take it to the next level. I've got investors that are interested. And I'm like, okay, send me your corporate documents. And they're like, what? And they don't even have an operating agreement. And
Right.
so, yes, we definitely help with all of that. In the meantime, what does that mean? That means that you're subject to the statute, to the state default rules, which you never want to be in a position to be in if you've got partners. You want to know what's going to happen if there's a fight. How can you kick someone out of the company? All that kind of stuff.
Sure.
But yeah, we absolutely help with all that.
Yeah. Okay. And so so they could just hire you like on a retainer and see make sure I'm structured correctly, or or should I set up a separate? I get this question all the time, and you guys like, should I set up should I set up a separate entity for this property, or how many properties, or I have a partner with this, or should it be
The answer is almost always yes. Separate liability. If someone slips and falls on this property and your insurance is going to cover it, we don't want them tapping into the value of the other property.
Absolutely. And the thing is, like, and obviously, especially with short-term rentals being such a big thing, especially in our market, they're like, hey, I owned, a 10-unit building, but then I have this one, property I've been Airbnb-ing, but I think it's, and it's always, I always tell people, of course, again, I'm not giving any legal advice or accounting advice, is it just depends on where you're at. Like everyone's threshold is different on liability or pain points.
Yeah.
Really,
Listen, true story. My own wife, we, like I said earlier, we have these 2 properties in downtown Fort Lauderdale, and they're very large lots. So we actually have 2 Airbnbs on our property. So we have our house and the other 2 are Airbnb'd out. Listen, you don't know how many times I've told her, why do you own this in your name? You need to have that property in an LLC and get a separate commercial policy. She doesn't listen. But you know what? Our assets are separate, so that's fine.
So, and that's the whole point, right? Like, I mean, you can only advise so much. I mean, that's your job is, and I always think it's kind of funny is that, you pay an attorney or you pay an advisor, quote unquote, right? And then you don't listen to them.
Well, that's one thing that I was going to say before, in the little what we have left is two things. The first thing is we thankfully are busy enough that and even if we weren't, we are not the firm. That's why we're the anti-stuffy business law firm. We are never going to pitch you something you don't need. Right. We're going to tell you, these are all the things you need. In order of priority, this is what we suggest. Then you decide. It's no skin off our back if you don't do it. But we are going to say that we told you. And then the other thing that I was going to say is really the majority of our clients, I would confidently say that 70% of our clients are on our general counsel retainer. So what that means is you give us $3,000, that goes into a trust account. We don't touch it until you need it. In fact, I've got like 3 different clients that have been in my brain for the last week that I need to email because they gave us money like over a year ago and they haven't done anything. And I reached out at the end of last year and they're like, no, leave it in there. So a lot of companies will do that. They'll hire us. And what does that mean? That you do have a contract that needs to be reviewed next month. You just reach out. You say, hey, I've got this contract. Can you guys review it? So that's what that money is there for. So even if you think you're going to need us in the future, but you're not sure, it's nice to already have that established because it's like having an attorney on call.
Absolutely. And I mean, I'm going to actually ask about, since you're talking about contracts, do you guys also work on if they're for non-performance, right? Like, or do you guys litigate, or do you guys handle that end of it? Or
we've moved away from litigation. There are some, like we actually just took on a complex derivative business suit that we're going to be handling, but because litigation takes up so much time,
Yep.
We currently don't do a lot of litigation. We're mainly corporate transactional, but the nice thing is we do a lot of business dispute resolution. So
Right.
because we're litigators, both of us actually are litigators by birth, like that's how we started as attorneys, and then we moved backwards into corporate transactional attorneys. We do try to resolve, and successfully we resolve a lot of them, not all of them, but a lot of them. And then once it gets to the point where it's litigation, we'll kind of decide, is this something we want to handle, or do we just want to send it out to someone? And we'll give you a list of litigators we've worked with that we are confident of will do a great job.
All I gotta say is I'm very happy I'm not either one of your spouses. I can only imagine the litigation between Amanda that happened.
Our couples therapist would agree with you.
I'd be like, oh my
It
God.
is not fun being married to an attorney.
Yeah. And
You
that's the
don't win
attorney.
many
And that's
arguments.
the attorney saying it.
Yeah, I would never want to be married to an attorney. I'm so glad my wife is not an attorney. And Amanda's husband is not an attorney
I
either.
know.
And I think we both 100% agree on that.
And just so you guys, those are the views of Florida Entrepreneur, not BPM rate. No, I'm kidding.
Yeah.
Unless you said that, I'm married to an attorney. How dare you? Right? I'll probably get that. I'll piss off that one person.
Yeah, no, listen, I got lots of attorneys that are married to each other, they even run law firms together. And I'm like, are you okay? But it's just not for us.
Yeah,
for sure.
I'm just messing. So I know we're pretty much almost out of time. So again, Michelle, I want to thank you so much for giving us an idea of how Securities and you want to really take your level to the next or your business to the next level. And we were at BPM RIA because we've been getting, part of the reason we did a webinar like this is we have a lot of I know there's some newbies, but we have a lot of investors that are moving their business. So we're trying to get to do more webinars that are higher level to really meet those needs on that portion. So, obviously, if you have my email or Alexa, email me and say, hey, it'd be great if we had if you guys did a topic like this. What you guys are starting to realize that BPM RIA, like Michelle and I had an offline conversation and this is what it's usually like, right? And that's what we wanted to really kind of do was, a few slides, but then it's me grilling her about 8,000 questions. She's like, oh yeah, I did this, I did that. And, you're kind of sitting in on Michelle and I just having coffee talk.
Yeah, I love it. It's so much more comfortable.
Yeah, it's because we're both cracking up. We're like, yeah, should we do this? And I'm like, no, let's just chat about what happens, in the securities world. And again, what I would do is, reach out to Michelle, Amanda, the team, and your real estate needs, run it by them. Obviously, they've been members of our organization for years. I personally know both of them. And besides being great attorneys, they're great people. So I fully vouch for them as people first, attorney second, on that end. And you really got, you guys make a big difference. And today's point is, if you're going to start really building your business, right? Your first job is to make money. Okay, I've already been doing that. Now you want to expand it, and you want to expand it and do something big, which is great. Do it the right way. It's going to cost you way more money, fines, all this other stuff that can happen to you if you don't do it the right way. We're not here to scare you, right? Today's webinar was not to scare you.
I hope
But
not.
it's just no, but more than anything is that sometimes you just don't know because you hear other people doing things and they're like, oh, so-and-so is doing this.
Yeah, oh, I get that all the time. And it's like, well, do you remember that saying when you were a kid and they said, if so-and-so jumps off a bridge, are you going to do it too? It's kind of like that.
Yeah, kind of like that. So I just want to, again, I know we're putting the information, and Alexis put all the information in the chat for Michelle and Florida Entrepreneur. Same thing, again, if you need to set up your corporations, operating agreements, you're ready to start, talking about setting up your fund, reach out to them. They're, again, fantastic. And, and I would say pretty much any real estate law. And if they can't help you, obviously they have a network of people that can.
Yeah, absolutely. Absolutely. We're always here to help. And, you can get a lot of information out of a consultation. We do 15-minute free consultations. And then there's always like the 1 hour paid. And the good thing with the 1 hour paid is that if you retain, and most people do, that gets credited to your first invoice. So it's not like you lose that money, you get that money back. And then Yeah, like I said, it's always nice to have a corporate counsel attorney, because that way you're not like rushing and you need something and maybe we can't help you because it's rushed.
Yeah, and I'm going to add also, so Michelle and Amanda usually don't do the free 15-minute. They're doing that especially for us at BPM Rio. So what I'm going to ask you guys, if you do book with Michelle or Amanda anytime, and I know they're very friendly and you could see all this stuff, just have your ducks in a row, right? Like you got 15 minutes. So, like be prepared on what you want to ask, have an intention of why you're calling versus, you're going to lose 10 minutes real quick, just being like, oh, so you got some lots in Fort Lauderdale. Like it's easy. They're both very amicable people and easy to talk to. You're going to lose your 15 minutes. So I beg you on is that do not take up their time for just kind of chatting.
Well, and I was going to say also that honestly, for BPM RIA people, when we see it come through that it says, how did you hear about us, BPM RIA? We usually give more than 15 minutes. We
Okay.
usually give like almost an hour. Yeah. So, but that's only for the BPM RIA, really. So I definitely, if you do book a consultation, make sure that you notate in the notes that it's from BPM RIA.
Awesome. Well, I'm not guaranteeing the hour, that's on them, but yeah. So, I mean, that's what I'm talking about is that, again, very generous, you and Amanda, and of course, some of my favorite people too. So, I think Alexa, you back in?
I'm here. Oh gosh, Michelle, thank you so much. I learned a lot today and it wasn't scary. I love to learn about this kind of stuff. It's just like preventative. So really important for everybody. Well, I'm going to send a thank you email to everybody after this event with all of Michelle's links and how to find her. So look out for that coming from Alexa at bpmria.com. But wow, I'm just so grateful. Thank you, Michelle. We got to do this again soon.
Thank you guys so much for having me.
Thanks, Michelle. We'll see you soon.
Yeah, definitely.
Have a great day, everybody. Thank you so much.
Thanks for joining us.
Thank you.
Bye.